Let me get to Mike McShane from the Show Me Institute, showmeinstitute.org. Mike, how are you?
I'm doing well. How are you?
I'm doing well, thank you. You know, yesterday on this Trinity Lutheran case, I had the opportunity to talk to Annette Keeney, who's the director of that church preschool, and also her attorney, who's helped take this all the way to the Supreme Court. Fascinating case, and has a lot of impact potentially, the decision on that in far beyond the Missouri border.
No, I think that's exactly right. I mean, there are 38 states that have the so-called Blaine amendments or anti-aid amendments that Missouri does that this case hinges on. So if the court were to find them to be unconstitutional, there could absolutely be implications in all those other states.
So let's go back to the beginning and why Trinity Lutheran had to challenge this to begin with.
Yeah, absolutely. I mean, they applied to a program sponsored by the Department of Natural Resources to get reimbursed for getting some used tires to resurface their playground. This was back in 2012. They applied to the program. Their application was actually ranked 5th out of the 44 groups that applied. That year, I think 14 schools, they didn't have enough tires for everybody, so they gave it to about 14 organizations. So Trinity thought it was sitting pretty. But it turns out they were denied because they are religiously affiliated. And the Department of Natural Resources said that was because of a provision in Missouri's Constitution, which says that they cannot give aid directly or indirectly to religious organizations. So Trinity, as their lawyer probably made clear to you, thought that this violates both their First Amendment and their 14th Amendment rights. So their right to freely exercise their religion and their right to equal protection under the law, because it's a religiously neutral program that is trying to give tires out to folks. So there's no clear reason why you should be discriminated against if you happen to be affiliated with a religious organization.
Yeah, it's interesting. Annette Keeney said yesterday that of the 100 and I think she said there were 103 or 106 kids in this preschool program, only 4 of them actually attended the church. So basically the community used this preschool program and were not necessarily connected to the church. So the vast majority of the kids there were not getting any sort of religious aid. If they had a softer surface on their playground, you could make that argument, certainly.
No, that's exactly right. And it makes us think about all of these other programs that the government runs on a religiously neutral basis. So think about it. If you're on Medicaid in St. Louis, you can go to Cardinal Glennon Hospital. I mean, that's a religiously affiliated organization. If you're a veteran, you can take your GI Bill to SLU, or if you're a low-income person, you can take your Pell Grant to SLU. There are all of these cases all around the country, and it was actually interesting that during the oral arguments, several of the justices just kept bringing up sort of instance after instance of like, well, what happens if the state has a program to get rid of lead paint somewhere? What if they have a program to, one they talked about, I guess, down in Oklahoma City after the bombing that took place there, they had a program to rebuild buildings around there. Well, what if one of them happened to be a church? I mean, they ran through sort of all of these to say, if this crosses some kind of line, then so many things that we clearly don't think cross lines and go so far as, quote-unquote, establishing a religion, which is what the Constitution would be worried about, then if this does it, then all of this other stuff clearly would, and there's no way that that's true.
Yeah, that's that's a good point. I guess if I'm not a lawyer, but I guess if they were to strike this down or reverse the decision, would it invalidate that Blaine amendment?
Well, so that's the question, is the degree to which the court will rule narrowly or broadly. So they could just rule very narrowly in the sense that this particular case was unconstitutional, but they won't necessarily weigh in on the broader question. And I got to be honest, after I was able to read the transcripts of the oral arguments, they're obviously not videotaped or anything, but if you read the transcripts, I think there's actually a pretty broad majority of the court. Justice Kagan was really critical of the state's decision. Justice Breyer was as well, which kind of makes me think there's likely a broader sort of coalition that would probably take a narrower ruling. Now, there may be another group and a concurring opinion, or others that say not only was it unconstitutional in this isolated case, but the principle in general, these Blaine amendments in general, are unconstitutional. So there are a couple different possibilities where it could happen: rule narrowly or rule more broadly. And if it's broader, then you're exactly right. That could have implications for states all across the country.
Well, I think in this country we've gone down a path for so many years where people automatically say, you can't do that, that's against the separation of church and state. And they don't even really understand what that meant. So maybe we can, if nothing else, we get a little better definition out of the Supreme Court as to exactly what we know what the founders' intent was. They didn't want a Church of England. They didn't want the United States government to say, this is our church, you have to go to it. I mean, they wanted to endorse religion, but there's a big difference in my mind.
No, exactly.
Yeah.
Well, and I think there's kind of selective outrage about this issue. You don't hear people going down to the state capitol saying, don't allow people to take their Medicaid dollars to St. Luke's in Kansas City or Cardinal Glennon, right? It only tends to happen when these things come up. But that's exactly right. And what I thought was interesting was while the debate was happening, there was this question, where do we set the line? Where does it work? And the lawyer for Trinity Lutheran, I thought, made this really kind of eloquent case. And he said, look, on one side, it's two different clauses in the First Amendment. On one side, you have the Establishment Clause, which says that the state won't establish a religion. And on the other side, you have the Free Exercise Clause, which says that the state won't prevent people from freely exercising their religion. He said those are basically the guardrails that the state has. You can't go too far on one side where you're establishing religion, but you can't go too far on the other side where you are impinging upon people's right to freely practice their belief.
Sure.
And it seems to me there's a pretty wide bit of runway in between those two where there are lots of these organizations that could possibly exist.
Yeah, but the left wants that. They want to turn that into a narrow little path to make sure that somebody doesn't walk out the other side of this and think that they can approve vouchers. Yeah, exactly.
Yeah,
exactly. Well, listen, Michael McShane with the Show Me Institute. I appreciate that. There's a great article on this at showmeinstitute.org. Thank you, my friend. Have a good weekend.
Thanks for having me. You too.
Absolutely.